All rise for the Honorable Judge.
Court is now in session in the case of Fernando F. Montes versus Lauren Betcher and Evelyn Betcher, in the case of the Hagen Resort, in a case of comparative negligence. Plaintiff, your opening statement.
I'm here to defend my client, Mr. Montes. My client was staying at the defendant's hotel when he jumped into the lake behind the resort. There was no warning signage or separation between boats and swimmers. When my client dove into the water, he hit a cement anchor, causing a huge gash in his head, and he cracked a vertebrae. After this incident, the defendant removed the concrete anchor from the lake. Over the trial, I will prove why my client should receive compensation for his injuries.
Ladies and gentlemen of the jury, today you're going to hear a case about a Mr. Fernando Montes. He's a gentleman that decided to drink a couple drinks. He was actually intoxicated and decided to do a flat racing dive knowingly into shallow water in which he's dived before. Today he's going to attempt to blame my clients, Ms. Lauren and Evelyn Betcher, the owners of the Hagen Resort, for the injuries he sustained during that dive into the water. What you need to understand is that Lauren and Evelyn Betcher, their property, their rights, and their duty to Mr. Montes ended at the beginning of that water. What you need to understand is that as a riparian owner, they are not responsible for the safe maintenance of property beyond the meander of the line of the lake. That line actually marks the boundary of the shoreline and the submerged land in which Mr. Montes decided to dive in irresponsibly. Even if you believe that they were responsible for the maintenance of the submerged lands, their responsibility only extends to the remedy of dangerous conditions that were known.
This is not a case of my client being irresponsible. He has made numerous dives at this lake before and is a proficient diver and swimmer. This hotel uses this lake as a resort for resort purposes. Thus, the duty of responsible care extends all the way to the lake. The defendant has a duty to maintain foreseeable hazards, which a cement block off the deck that my client hit was. A breach of duty occurred because of the lack of signage and failure to rake the lake from hazardous situations. My client's injuries would have never occurred if the defendant held up their duty to protect their guests.
The court has ruled in favor of the plaintiff. It has been determined that the defendant violated their duty in one or more of these aspects. They failed to warn the dangers of diving off the boat deck. They failed to periodically rake the swimming diving area and search any dangerous obstructions, and they failed to segregate swimming areas from the boating area. The jury has concluded that this has been a case of comparative negligence in 90% the defendant's and 10% the plaintiff's fault.
After reviewing the case between Betcher and Montes, we affirm the lower court's decision.